Everyone, welcome back to the channel. My name is Varun and I am a legal intern at LEXIS and Company. Today I am going to discuss about liquidated damages. The essence of a contract begins with the promise of honoring the contract arising out of the agreement so entered. However, the circumstances are not evergreen. While deciding the remedies of the non-performance of the same and inserting the liquidated clause proves to be one of the most savage clause of the parties who is prone to suffer to bear the burden of non-performance or breach of the contract. The modus operandi of such clauses happens to be quite useful in cutting out the ambiguity related to the subject matter. The liquidated damages clause speaks for the agreed amount fixed as per the anticipation of the parties if either of them fails to hold their end of the bargain as stipulated in the contract. One of the important features for the inclusion of such a clause is to save time, money and energy on potential disputes in this regard. Now, where there is a contract, there will be a breach. Where there is a breach, there will be damages. Where damages occur, there will be compensation. Compensation inevitably generates types of damages, that is, liquidated damages and unliquidated damages. How are liquidated damages different from unliquidated damages? First, I am going to tell you about liquidated damages. At the time of making a contract, when the parties fix the amount of compensation for the breach of contract or the amount of loss at the time of the breach, so it can be in the form of liquidated damages. Liquidated damages are the estimation of loss suffered by other parties. In liquidated damages, the amount of the compensation is predetermined. Liquidated damages are mostly given in the Contract Act, as in this it is already decided that any person who breaches the contract, so how much money they have to pay. Now, unliquidated damages. In law of torts, unliquidated damages are given. In unliquidated damages, it is not predetermined as it is liquidated damages. In this, it is not predetermined that how much compensation will be given on the infringement of the right of a person. The amount of compensation will be decided by the court on a case-to-case basis by determining the facts and offences. It is observed that the offence is how many graves and dents. When are liquidated damages awarded to a party? Liquidated damages are awarded under Section 74 of the Contract Act when the contractual parties have right to claim the amount and no question of ascertaining damages arises. Section 74 of the Indian Contract Act further deals with the situation where both parties to contract agrees that the contract itself will stimulate the penalty for the breach of the contract, that is liquidated damages. Section 73 of the Indian Contract Act says that if there is no loss from the breach of contract, then no damage will be awarded. Hence, the damage will only be awarded when there is actual loss from the breach. Compensation is not paid for any remote or indirect loss or damage sustained because of the breach. How are they calculated in construction? In case of a breach of contract, in construction contracts, there is a clause that offers that the other party will pay liquidated damages to the owner of the construction project if they fail to complete the allocated work at the date agreed on the contract. Liquidated damages are generally calculated on a daily or weekly rate, and the amount depends on the value of the property. As it is liquidated damage, so the value is predetermined. Calculation of liquidated damages include storage cost, loss of rent, fees, loss of income, finance costs, rental costs. The general formula to calculate liquidated damage is contract cost plus total extended cost plus total project cost plus contract duration, that equals to liquidated damages. When do they not apply? If the party enters into a contract with the state or central government for the performance of an act in the interest of the general public, then a breach of such contract makes the party liable to pay the entire amount it mentioned in the contract. Liquidated damages are not applied when, number 1, waiver. When there is a breach of contract, the employer can either elect to affirm the breach and claim liquidated damages or ignore the same grant continuation of the contract. In case he chooses not to elect the breach as a repudiatory breach, he is disentitled to claim liquidated damages. He would have said to waive off his right to claim liquidated damages, and the right to claim the same will be forfeited. Number 2, employer himself is at fault. Where a clause is in the contract stipulated levy of liquidated damages if the work is not done with due diligence and the delay occurred due to failure on the part of the employer to supply materials in the required time, it was held that imposition of damages by the employer could not be justified. Cases and examples. according to the facts of the case Oil and Natural Gas Corporation Limited versus Saw Pipes Limited on 17th April 2003, the following was observed by the court. The law is very clear on this point, that if the terms and conditions of the contract are obligatory to be taken in consideration before arriving at the conclusion, the party claiming damages are entitled for it. If the terms and conditions are clear and explicit, stipulating the liquidated damages in case of breach of contract and unless it is held that such aforementioned damage or compensation is unreasonable, the party who was committed breach has to pay such compensation which is stated under section 73 of the Contract Act. In the case of Thermex Babcock and Wilcox Limited versus Adel Commission of its 2nd March 2007, it was held that in the contract agreement with Canoria Chemicals and Industries Limited, the clause of liquidated damages states that in the case of delay in the commission of the complete equipment beyond 25th October 1995, liquidated damages at the rate of 1% per week, subject to maximum the X work price, shall be applicable. So by this, they have to pay compensation on the fault of their part. That's it for today's video. Thank you for watching. If you guys have any questions regarding the video, please do ask in the comment section, and don't forget to like, share and subscribe the channel LEXCLIQ.